sooner we get started, the sooner we can let you all out the door. And I know at this point in time, you're really starting to feel the crunch, so, yeah. And I know whatever commercial course you're doing, you all have a benchmark quiz test next week. So I am aware of all of the above. And with that in mind, when we set this schedule a long time ago, and a lot of thought goes into this schedule, and we try to avoid conflicts, and then we discovered there was a conflict. So we're going to switch things around for those of you who are taking Kaplan. So the Florida Con Law lecture that was scheduled for next Friday, which is what conflicts with the Kaplan originally had that midterm scheduled on a different date, but it is now scheduled on that Friday. So we are going to move Judge Shepard to Tuesday, June 28th. It is a date that he has available. We have to work with his schedule as well. And we will be doing the barbecue after his session on the 28th. So again, please adjust your calendars accordingly. It's an important lecture, obviously, especially if you haven't taken Florida Con Law, but even if you have. And then, because that would have made it too close to my next session, we're going to take my session and bump it forward to the following week, to Wednesday, July 6th. The rest of the schedule remains the same. Any questions about that? It's been emailed to you, we posted it. I will remind you again, I do apologize. We worked with the information that's given to us at the time, and unfortunately, Kaplan somewhere along the line changed its schedule. So, if there are no questions, let me remind you to please feel free to send essays to me. I have been turning them around pretty quickly. I'm in the middle of one last set that was sent to me yesterday, I guess. But otherwise, I am up to date, so please feel free. You can send me essays that you've written for your commercial course if you don't have time to write other essays. It's always a good idea to get more than one pair of eyes to take a look at the essay. Sometimes I'll say something different from what you see in the commercial course. But I am, again, very happy to take a look at your essays. All right, and Sarah's collecting, and she's already talked to you again about the release questions, if there's anybody out there who has not already obtained the release questions. It's a good idea to do it now. All right, we're going to start with some wills and trust questions, some multiple choice questions. There is certainly a possibility that you'll get wills administration in the multiple choice section of the exam. It's kind of due. I think they're not just kind of. I think they really are due for a trust question, and it is possible. They don't do it often, but it is possible for them to have wills administration in multiple choice and trust in essay form. So a good knowledge of these two areas is a good thing. Now the question set that you downloaded, we're not going to do all of the questions, so then that leaves you some more questions to play with. It's always hard to find Florida multiple choice questions, and let me explain why it is so hard to find Florida multiple choice questions. Because the MBE questions are written in a very identifiable style, and you know how to do it. So lots of people write those questions. The Florida questions, they're kind of off the wall. They are not written in MBE style. And it's very hard to duplicate them. It's hard to write bad questions, I gotta tell you. And they are bad questions in many cases. So no one spends a lot of time writing Florida multiple choice questions. It is what it is, which means, of course, then you've got to put a premium on your knowledge. So we're going to do some of the questions in the set. I leave the rest for you, but it'll give you a sense of the types of things, particularly in wills. I have some trust questions at the end, and then we will do a trust essay, and then finish up with property, everyone's favorite. So, I know, don't we all love it? I would like for you, and you know the drill on the clicker, so we're going to do it one question at a time, and I do have to direct you since we're not doing all the questions. Question number 1. I think you registered. I look like it. If you think it's not registering, then we do have some more clickers. Because we are missing a bunch of people here. Okay, anybody else want to ring in? All right, let's see how we did. Interesting, including E. We can assume that E is not the correct answer, right? And you know, we can joke about it, but remember when you get to the exam, you got 4 choices. Even on the Florida portion, you have 4 choices, right? And you got a 25% chance of getting A or B or C or D. You have a 0% chance of getting E right. And so pick one of the 4 that maybe is right if you don't know the answer. The correct answer here is C. Now, to get the right answer, you have to draw the picture. In this area, if you don't draw the family tree, we're going to draw the family tree here, then you probably won't get the right answer. So we've got our Dan, who will become our decedent. He's got 3 kids. And then Raccoon has Rocky, Nancy has Lil and McGill, Doc has Gidgeon, and Gidgeon has Dakota. That's our tree. Now, who's dead? Dan, our decedent's dead. We've got Raccoon dead and Nancy dead. And Doc is dead. So who gets Dan's property? He's our decedent. We're in Florida. What method do we use for intestate distribution in Florida? Strict for stirpes. Yeah, strict for stirpes. So for strict for stirpes distribution, we look for the root generation. The root generation is always the first generation after the common ancestor. Always. Even if there's no one living in that generation. Different from the Uniform Probate Code. So if you studied Uniform Probate Code in your wills and trust class, put it out of your mind. Florida, strict for stirpes, root generation. Who's our common ancestor here? Dan's our common ancestor because he gave birth to all these kids down there, right? So our root generation is the kids. Now, we divide up the property according to the following. The number of persons born into the root generation who either survive or who leave lineal descendants. Some of you may have made that mistake too. different again from the Uniform Probate Code. So we had 3 persons born into the root generation. They all predeceased Dan, but each left lineal descendants. So how many parts do we have? 1, 2, 3. What do we do with those 3 parts? Easy one is Rocky. Rocky steps right into Raccoon's shoes, right? Who steps into Doc's shoes? Gidgeon does. Dakota doesn't take anything because if the person in front of you in line is still alive, you take nothing. So then we take Nancy's part, and what do we do with it? We divide it between McGill and Lil, which gives us the following. 1/3 to Rocky, 1/6 to McGill, 1/6 to Lil, 1/3 to Gidgeon. Questions? You've got to be able to do that kind of basic math and draw the picture and always, always, always look for the root generation. Questions? All right, let's do number 2 then. You can grab a clicker on your way in. Anybody else? I think we're a few short, but close enough. Now, chances are good when you answered this question. Let's see. You recognize the fact pattern, and some of you just kind of answered based on the fact pattern. And B is the right answer. However, I want to take it a little further. So we are talking about half-blood, right? And on the Florida multiple choice, whether it's Florida Evidence or Florida Wills or Florida BA, whatever it is, you know they're going to go for the Florida distinctions. And we use the old common law approach to half-bloods. The Uniform Probate Code doesn't. But when you're talking about half-bloods, and of course a half-blood, they share one parent but not 2. We use a formula if we have collateral inheritance to the side. We do not use the half-blood formula if we have lineal descendants. If it's lineal descendants, everybody takes equally. So in our picture, of course, we're talking about collateral, which I'll illustrate in a moment, and we use a formula. So let me go there. Look at that. Or, hang on. Let's do this. All right, so once again, our picture. We've got a mother and a husband number 1. They give birth to Martha. And then husband number 1's out of the picture for whatever reason. We really don't care. Mother marries husband number 2. And they have 2 kids, Rita and Bonnie. And then mother's out of the picture, husband number 2 is out of the picture, and Rita is our decedent. We're talking about collateral inheritance because Rita has no lineal descendants, right? She has no kids, no grandkids, whatever. So, collateral to the side, her brother, or in this case, just her sisters. We use a formula. So, here's what you want to do. And if you write this formula down, if you use the formula, you're going to get these questions right, and a lot of other people won't. We ask, with these 2 people, Martha and Bonnie, are they related by the half-blood or by the whole blood. If they are related by the half-blood, we give that person 1 part. Martha gets a 1, because she's related by the half-blood. Half-blood because she shares a mother but not a father with our decedent. Anyone who's related by the half-blood gets a 1. Anybody who is related by the whole blood, that's Bonnie in this case, gets a 2. So no matter how many individuals you have, they give you a very complicated set with 3 over here and 4 over there. Anybody who's a half-blood gets a 1. Anybody who's a whole blood gets a 2. And then you add up all the parts. 1 part plus 2 parts gives you, guess what? 3 parts. A little bit of math here. Now comes the part that people who don't like math really hate. But it's not that difficult, a formula. Because you take the total, the sum, 3 in this case, right? And that becomes the denominator in your fraction, the bottom part of your fraction. And in the numerator, the top part of the fraction, you put the part. So, Martha got a 1, we put 1 over 3, what do we get? 1/3. Bonnie got 2, we put the 2 over the 3, what does she get? 2/3. And easy in this fact pattern, we don't have a lot of people, and it's one you've probably seen before, but if you get a different fact pattern with more brothers and sisters, use that formula and it will get you the right answer every single time. And again, if it's collateral inheritance, if mother had been our decedent and we had Martha, Rita, and Bonnie alive, 1/3, 1/3, 1/3, because it's lineal descent. Any questions? All right, we're going to skip over number 3. You can do that by yourself. Number 4, and I'll get for those of you who are reading along, let me get that up. Give me a second here. Anybody else on this one? All right, see how we did. Pretty good. But I was kind of watching as we went along, and it took a while for D to surface as the right answer. And you guys did better than people usually do with this question, because a lot of times I see people going back and forth. Oh, but that one looks right, that one looks right, that one. What's the call of the question? Incorrect. Reading comprehension. So if you picked any of the other ones other than D, it's probably because you didn't read the call of the question carefully. Remember with multiple choice, folks, whether it's Florida or it's MBE, half the exam is reading comprehension. And will you know every rule? No way. But can you afford to miss a question because you misread it? No. Because that's what's really going to hurt. So, we're talking about revocation of a will. Once again, they're going to test the places where Florida law is different from the UPC. And here's a place where it is. So, A says Billy can revoke his will by a subsequent writing. that's executed with all formalities. Of course he can. That's a permitted method of revocation. B says he can revoke it with inconsistent provisions. Yes, of course you can. Florida statute permits revocation by inconsistent provisions. C says he can burn it. Yes, you can revoke by physical act, but what can you not do in Florida? Partial revocation by physical act. It's all or nothing in Florida when it comes to physical act. If you're going to rip it up, rip the whole thing up. You can't just rip off one provision or draw a line through one provision. Any questions? All right, number 6 will be the next one, and give me a second for those who are reading along. I'll get that up for you. Anybody else here? All right, see how we did on this one. Oh, very good. All right. You're actually doing very well. So let's talk about why A is the right answer, although most you can tell me. Because the concept that we're talking about here is we've got somebody who predeceased our testator, and so the concept is, fill in the blank word? Anti-lapse. Lapse and anti-lapse. But a gift lapses if the beneficiary either is not living when the will is executed or predeceases the testator. So we're talking about lapse, and then the question is the gift protected by the anti-lapse statute? You know, vocabulary matters a lot when it comes to the exam. So if you're writing an essay, because you can have lapse in either a will or a trust. If you are writing, then use the vocabulary properly. The gift to Beethoven will lapse unless it's protected by the anti-lapse statute. Now, we have a gift in a will. So we are applying, guess what? The will's anti-lapse statute. And up until recently, we had a markedly different trust anti-lapse statute. Now, this latest version of the trust anti-lapse statute, they tried to make it comparable to the will's anti-lapse statute. Did not do a good job, but they did a very poor job in drafting it, but that's where it's at. So let's talk about what those principles are. You've got your predeceased person, and the gift will lapse unless two things, right? Unless that person is what? A descendant of the grandparents of the decedent, and that person also had what? Somebody's got to take the gift, right? And who's the somebody?
Oh, they had
Lineal descendants.
Lineal descendants. Got to have both those things. Someone who is a descendant of the grandparents of the decedent and who left lineal descendants. And despite the fact that it's very poorly written, the trust anti-lapse statute also now does the same thing, we think. So, in this case, we're looking for the situation that illustrates that rule. You'll notice, of course, that there are facts added into the answer choices here. You will not see facts added into the answer choices on the MBE exam, but you may in Florida. It's an older question style. So I have given you in these questions some older style questions because Florida doesn't follow the MBE rules. Now, most of you picked A. It says the kids will share if Beethoven was Jude's brother. Well, if Beethoven is Jude's brother, he's a descendant of Jude's grandparents, right? And he left lineal descendants, Sadie and Mackenzie. B, when I originally did the question, was designed to evoke the trust anti-lapse statute because it didn't used to have a relationship requirement, but that's back in. Now, one last thing to remember, nobody picked D, which is good, and I think maybe just one or two picked C. It is possible to draft out of the anti-lapse statute, whether you're talking about a will or a trust. What you should look for is express survivorship language in the gift. If it said to Beethoven, if Beethoven survives me, we have drafted outside the anti-lapse statute, which means there's no protection, even if you have someone who is a descendant of the grandparents and who leaves lineal descendants. So make sure you read the language very carefully, and if there is that survivorship language, or an alternative gift to somebody else, then you do not apply the anti-lapse statute. Any questions? And again, that will also be true for the trust anti-lapse statute. Okay, we're going to jump forward a little bit now in the questions. Again, you can do the rest on your own, and if you have questions about them, let me know. We're going to go all the way to number 12 because I want to do a little bit of wills administration, which is boring stuff that never gets taught, including by me, in your wills and trust class. So if you have the questions in front of you, go to 12. If you're waiting to read, give me a second, and I will get number 12 up. Okay, anybody else on this one? D is actually the right answer. So let's talk about why D is the right answer. Once again, it's something you almost certainly didn't cover in your wills and trust class. So whatever commercial course you're taking, make sure you take some time to review the probate process in your outlines, because they do like to test this kind of stuff. So we're talking about where we commence the probate proceeding. First statement says, in the county in which the decedent was a resident at the time of his death. Yes, if the decedent was living in Florida at the time, you go to that county, and that's a must. If your decedent is living out of state, and if you've got somebody who's living, for example, in North Carolina, you may need to probate a will in Florida, right? Because you may have Florida property, number one, or the will could even stipulate the choice of law. It's not impossible to have someone living in another state with a will probated in Florida. So A says go first to the county in which the decedent was living, but if the decedent is a non-resident, then quite logically you go to the county in which the decedent owned property. If for any reason your decedent didn't own any Florida property, but you're still trying, and was not a Florida resident, but you're still trying to probate the will in Florida, then you go to any county in which a debtor of the decedent resides. So all three of those statements are correct. And once again, just take some time with that part of the outline. All right, number 14. Anybody else on this one? Pretty good, and I'm very happy to see that nobody picked D. Now, not to say that the trust, the probate code and the trust code for that matter, attorneys get a lot of benefits here, but this isn't one of them. The attorney is not automatically the personal representative. We do indeed, if it's an intestate estate, we go first to the surviving spouse if there is one. If there's no surviving spouse or the surviving spouse declines to serve, where do we go next? Does anybody know? You're not going to know it from your wills and trust class. I don't teach this stuff, and probably nobody does. You go to the person selected by a majority in interest of the heirs, and I want to explain what that means. Because again, you probably haven't seen this particular set of rules before. When we say majority in interest of the heirs, we're not talking about the number of heirs. We're not saying, okay, this person has 6 heirs and so 4 can select. We're talking about the size of the shares. Whoever has more than 50% of the estate, however that works out. And then, if they can't agree, then you go to the heir of the nearest degree of kinship. So once again, your order is surviving spouse, then person selected by the majority in interest in terms of the size of the gifts, and then finally, the heir of the nearest degree of kinship. That's for an intestate estate. What about for a testate estate? Does anybody know? Where do you think you should start first? Kind of logical. Yeah. Thank you. You guys are smart. Yes, you go to the will. The person who's designated in the will gets first preference, right? Of course. If that person isn't alive or declines to serve, then where do you think you go? Yeah, good. Person selected by the majority in interest of the beneficiaries under the will. Same thing. Not the number of beneficiaries, but the size of the gifts. And then if you do not have an agreement by them, you go to any devisee. So once again, under the will, person named in the will, number 1. Number 2, majority in interest. and then who selected by the majority interest, and then number 3, any devisee. All right, we're going to go all the way to the end now. The next questions deal with trust. We're going to talk about trust in the context of the essay, but I wanted to do this question because it really doesn't come up in the context of the question, and one of the things that sometimes falls out in your wills and trust class is trustee duties. You run out of time. And depending on who you had, you may have spent more or less time on trustee duties. I can promise you, if you get a trust essay, trustee duties are going to be very important. So if you didn't spend much time on trustee duties in your wills and trust class, that's another part of the outline that you really want to focus on. So that's question number 23. And if you are reading along, give me a moment, and I will put that up for you. Okay, anybody else out there? Looks like we're pretty much all registered. Let's see how we did. Pretty good. So, we're talking about trustee duties. And of course, the trustee has many fiduciary duties. We look at A, and it says Murphy sold Avery Hall a trust asset to Jim for the fair market value without a court order. Our trustee has very broad powers, tantamount to the powers of a fee simple owner, right? And so unless the trust says that the trustee needs a court order to sell real property, the trustee may sell real property without a court order, unless probably it's homestead. So leave homestead aside. We'll talk about that one later. But otherwise, the trustee can sell, and so it's not a breach of fiduciary duty. B says Murphy received a fee for administering the trust. Most trustees want to get paid. That's why people, or especially financial institutions, agree to serve as trustees, and a reasonable fee is always acceptable. C, on the other hand, of course, is the right answer. We'll come back to it just so we can spend a little more time on it. D, we have a delegation of duties, administrative duties. Now, once upon a time, traditionally, the trustee could not delegate duties at all. But under Florida law today, duties are delegable unless, of course, the trust document makes it clear that the trustee must perform personally. If a trustee delegates duties, remember, of course, then the trustee has a duty to supervise, first of all, to choose the delegatee, properly with due care and then to supervise. Now, coming back to C, if the trustee buys from the trust or sells to the trust, obviously that's problematic. Does anybody know what it's called in Florida? If you
Self-dealing?
self-dealing, good. And in Florida, self-dealing is, there's a phrase, you may not have covered it yet, but it's important. It's an important phrase, especially if you have to write about it in an essay, which you easily could. It's called voidable per se. Not void, but voidable per se. Self-dealing, voidable per se. What does that mean? I think it's kind of a stupid phrase myself, but because if it's voidable per se, voidable means you may, not you must. Voidable per se means that the beneficiaries may avoid the transaction if they don't like it, and they don't have to give any reason for not liking it. They just say, we don't like it. Voidable per se. They can automatically avoid the transaction. If it's self-dealing, the trustee deals directly for his or her benefit with the trust. Contrast that with conflict of interest. In a conflict of interest, the trustee benefits not himself or herself, but rather a close family member. And then we say that the transaction is presumptively voidable, which means it's voidable, but there's a further inquiry. A phrase that's oftentimes used with with self-dealing, is no further inquiry. You're done. They don't like it, you're done, you don't have to ask any questions. With conflict of interest, presumptively voidable, further inquiry may occur. And if the trustee can prove that the transaction is a fair transaction, that presumption of voidability is rebutted. So there's a big difference, easy to test, and particularly it's vocabulary that you would want to have in writing a trust essay. Conflict of interest is just presumptively voidable, and the trustee may rebut the presumption by showing that the transaction is a fair one, fair market value, for example. And you make a further inquiry. Any questions about that? All right, so what we're going to do now, before we take the break, we'll go ahead and do the trust question. Let me put it up for those who are going to read it. For those of you who have it, obviously take a few minutes just to read through it and pick out your issues. But I'm going to tell you as I close this stuff up, you guys did a really good job with these questions. So you can pat yourself on the back. And why won't, there we go. All right. So let me get that question up. Right there. All right.
No, it's this one.
All right. It's a little small. If you're in the back, you might have trouble reading, but that is the entire question. Okay, I know you're not completely done. There's a lot in this question, right? But let's go ahead now and kind of walk through the facts together. And what I challenge you to do, as we're walking through them together, I want you to look at what you've noted down and see how much of what we're talking about now you saw in the fact pattern. Because that's a key, folks. If you read the facts carefully and you say, what is this fact doing here? What does it mean? Why is it there? Then you'll know what to write, and the essay will almost write itself. Of course, you have to know a little bit about the law, right, to know what the facts are telling you. So we'll start up at the top. Sam is a Florida resident. Okay, that one's easy, because it's telling you, guess what, apply Florida law. Sometimes the question doesn't tell you where it's set. Occasionally you're going to see that in some of these essays, unless they very specifically tell you to analyze the case under the federal constitution, which they do sometimes. Then you're going to say, if they don't tell you, you're going to say, I'm going to assume it's set in Florida. And then you will apply Florida law. So he's a Florida resident. He dies survived by his wife and his 2 adult children, twins, Kathy and Clay. Okay, it doesn't matter that they're twins, but it does matter that they're adults, right? Why?
Because if not, the wife would have done everything.
Well, that's intestate distribution. But we're talking about a phrase that you should, anytime you pick up a wills, trust, Florida common law question, you should be thinking about this particular phrase, or word. Homestead. Oh, homestead. We've got a wife, we've got children. And he's executing a will. He's going to devise property. He devises his entire estate. In Florida, if you have a spouse or a minor child, you cannot devise your homestead to anybody. But he's got 2 adult children. It's minor child. So he can devise, if there's a spouse and no minor children, no children or no minor children, then you can devise to the spouse. But what do we know about the spouse in this case? What did she do? She waived all of her claim. She waived all of her statutory rights, homestead, elective share, the exempt personal property, family allowance. She waived all of those things. Predetermined spouse if she happened to be one as well. So his will devising his entire estate is going to be valid. But look right away what's in there that you didn't see. And do you want to spend a paragraph talking about homestead here? No, because they don't give you a lot of homestead facts. But you would note, you should note that in this particular case, the will devising the entire estate is okay, and it can include the homestead. Now, it's devised to Tom in trust for the twins. Vocabulary, vocabulary, vocabulary. We have a trust. What kind of a trust is it?
Testamentary trust.
Vocabulary. It's a testamentary trust. Why is it a testamentary trust?
Because it says there.
Because it's in the will. It's a testamentary trust. Let me explain the difference. And please, if you get a trust question, please know the difference. You'll get a lot of points that other people won't if you know the difference. So, a testamentary trust is a trust that is created in a will. The will spells out the trust. And they do, by the way, they do like to test testamentary trust. It's tested frequently. One document, a will, which creates the trust. A pour-over trust is something different because you have 2 documents for a pour-over trust. You've got the will properly executed and you have the trust properly executed. What do you need for a pour-over trust? First of all, the 2 documents. The trust must be created when? Before or concurrently with the will. The will has to refer to the trust and pour assets into the trust. You don't have 2 documents here. You have 1 document. It's a testamentary trust. They have to tell you that there's a will and the trust. And that trust is likely to be revocable. It doesn't have to be, but it's very likely to be revocable, which means it can be changed anytime during the testator's life, and Settlers Life. And if it is a true pour-over trust, what else do you know about a pour-over trust? Doesn't have to be funded until when? Until the settlor dies, which of course is a big exception to the trust race requirement. Remember, a trust has to have a trust race or it can't arise. But we have two statutory exceptions in Florida. One is the pour-over trust, and the other is the life insurance trust, which they have tested from time to time. It's the same thing. The life insurance policy funds the trust at the death of the settlor. So make sure you note that down, the difference between a testamentary trust and a pour-over trust. Don't make the mistake. You're going to get a lot more points than the person sitting next to you, because I promise you, most people get it wrong. All right, so the will devises everything to the trust for the kids, and let's look at the provisions of the trust. The trustee is to pay to the twins all income, okay, that's not unusual, and as much of the principal, power to evade the principal, in the sole discretion. If it's in the sole discretion, the trust is what kind of a trust?
Discretionary.
Discretionary trust, good, okay. Deems necessary for the health, welfare, and education of the twins until they reach the age of 35. And that age of 35 is there for a reason. As soon as I see that in a fact pattern, I know something. I know that one of the issues is going to be, can you terminate the trust early? Anytime you have an age limitation like that, automatically think about termination of the trust. And then the remaining assets, if any, are distributed to the twins in equal shares, okay? The testamentary trust contained a spendthrift clause. So you know you got to talk about spendthrift clause. Most trusts today do include a spendthrift trust. If we've got a spendthrift clause, we are going to have some creditors knocking on the door. You know that's going to happen. Tom is also named personal representative under the will. Not necessarily so unusual, but why do they have him as both trustee and personal representative? Because he's going to do some things, and we're going to need to contrast the powers of the trustee to the powers of the personal representative. It's why I like to use this question occasionally. It's a difficult question, but it allows us to talk about some things that you wouldn't normally talk about in your wills and trust class. Now, guess what? I already knew it was coming, but Sam's estate consists of his homestead. You knew that was going to happen. Valued at $100,000 and $10,000 in cash. Wow, he doesn't have much. City Hospital filed a valid claim against the estate for unpaid medical bills stemming from Sam's last illness in the amount of $25,000. If you haven't reviewed wills and trusts yet, and you may not have, it usually comes kind of late in your course, make a little note that one of the things that you need to memorize, because I don't know why, but they love to test the categories for satisfaction of claims. And there are 8, we'll get to them in a moment, but learn them, because it could show up in multiple choice or essay. And it's the kind of thing, again, it's not that hard to learn the categories. If you know them, other people will not. So we'll get to those categories in a moment. Now, Tom liquidated the assets of the estate. He's liquidating the assets. It doesn't tell you which hat he has on. Is he liquidating them as the personal representative or as the trustee? We have to talk about what that means and what the differences are. And then he distributes the proceeds to the trust. So he's probably liquidating as the personal representative. They just haven't made it as clear as they should. After taking possession as trustee, he invested all the proceeds in a local construction company. Bells and whistles, because
Due to the diversity.
he didn't diversify. Good. Remember, trustee duties are going to be important. We'll come back to what that means here. But the investment was successful, so we'll talk about why that's important. Tom supported the twins from the trust while they obtained their college education. Does it fit within the purpose of the trust? Sure, because it was health, welfare, and education. He paid $20,000 for a life-saving liver transplant for Clay. Probably costs a lot more than that these days. What do we think? Okay?
Good.
Yeah, help, right? Then he made down payments on the twins' homes after they graduated. Yeah, probably. Health, safety, welfare. Health, welfare, probably. The twins are now 31 years old. What did I tell you? They're not 35 yet, and they're getting antsy. They want their money now. So we're going to have to talk about termination of the trust. And they're successful in business. They don't want this trust stuff anymore. In celebration of Kathy's real estate business closing 2 million sales in 1 year, Tom purchased an automobile for her with $20,000. Yes? No?
No.
No. Plus $2 million in sales, she can buy her own car. All right, so no, can't do that within the trust. Kathy wants to, she did assign, her interest in the trust to the local zoo as a charitable donation. Admirable, but spendthrift, thank you, yeah, spendthrift. So we'll come back to that one as well. Kathy, Clay, and the zoo would like, of course, to terminate the trust. So we're going to have to talk about termination. The remaining principal balance of the trust is $34,000. Anybody know why that's there?
If it's
Under 50,000.
Under 50, not 75, under 50,000. The trustee acting alone can terminate the trust. So now we get to the call to the question. And I want to beg you, because as I'm reading essays, I see a lot of people just kind of writing. Answer the call of the question in the order presented in the call of the question. Really important. You want to maximize your points. You just don't write this bunch of stuff, anything that comes to mind. You answer the call of the question. And so you're going to see that that's, when I get there, okay, gotta do it this way. That's how I've set up my answer. They ask first about the liquidation of the estate. Second, about funding the trust. Third, about administration of the trust. And fourth, termination of the trust. In that order, you are going to get a lot more points if you go point by point as set forth in the call of the question. Now, I want to kind of caution again as we go through this presentation. There is a lot more information in it than you would write in your answer. I'm going to try to hit the high points of what you should write. People use these as study guides, and there's a lot of good stuff in here, particularly about procedure that you don't normally get, again, in your wills and trust class. But don't think that you're going to write all that stuff in your answer. But let's start first with liquidation of the estate. And we want to know, when he's selling this stuff, is he selling it as the personal representative or the trustee? And we've got to talk about the homestead. The facts are fuzzy, so we want to cover both personal representative and trustee, and what happens if there is an improper sale of the homestead. All right, personal representative. We all know what a personal representative is. And the question is, what does the personal representative have power to do? Now, personal representative has a lot of powers, but they are not as extensive as a trustee. Because the trustee actually gets legal title, right? Personal representative does not. So, in particular, he is going to sell the homestead, because it says he sells all the assets. We need to know, can he do so? First thing you want to know is, does he have letters of administration? If you're a personal representative, you can't really do anything until you get your letters of administration. Sometimes it'll relate back, but the first thing you're supposed to have, letters of administration. So we ask here, they don't tell you anything. Just make sure you keep an eye on it. If he doesn't have letters of administration, then he doesn't have the power to act as the trustee. As the personal representative. Title's not going to pass until the letters are issued. But once they're issued, as I mentioned before, we can relate back. If, on the other hand, he does have letters of administration, then he's got power to sell property. However, we're talking about real property. And a personal representative is a little more limited than a trustee in terms of selling real property. Because a personal representative cannot sell real property unless one of two things happens. The will authorizes the personal representative to sell without a court order, or a court order is obtained. Well, we don't know in this case. They don't tell you that, that the will authorizes sale without a court order. They don't tell you there is a court order, but guess what? Even if we had an authorization in this will, it's a frequently included provision in a will, saying that the personal representative can sell real property without a court order. What's the property again? Homestead. Personal representative can never sell homestead without a court order, period, end of story. And probably a trustee cannot either. So, any way you look at it, if Tom was acting as a personal representative when he sold, and he probably was, that sale of the homestead is invalid without a court order. What does that mean? And it's got to be an important point in this question, probably one you weren't even thinking about. He sells the property improperly without a court order. What's the effect of the sale? Anybody want to tell me? If he's acting as personal representative, the sale is void. No title is transferred. So he can't sell the homestead, and if he does, the transaction is void, unless, of course, the beneficiary is ratified. Which they might have done in this case, right? Because it seemed like that they were happy to have him sell the homestead. They're adults, they're out living there. They can always ratify. Now, if he is, which is what I just talked about, the personal liability, if he's acting as the trustee when he makes that sale, the rules are a little bit different. Because trustee, again, has tantamount to fee simple ownership powers. So a trustee, as I mentioned before, may sell real property without a court order unless the trust document says no. And usually the trust document will not prevent the trustee from selling real property. But it's homestead. And the rules aren't real clear here, but probably if it's homestead, the trustee still needs a court order. Now, here we come to a difference. Where are we going there? Okay, if we have a sale by the trustee without a court order, it's an improper sale. The trustee has breached his fiduciary duty. But we have a different effect. Because if the sale is to guess who? A subsequent bona fide purchaser. If you sell to a bona fide purchaser, the transfer is good. Contrast that to the transfer by the personal representative. It's void. Here, it's good as long as it's to a bona fide purchaser. And there's no duty for the purchaser to inquire about the authority of the trustee. Question?
They have to be a bona fide purchaser. It can never be that there's like a transfer as a gift.
Then it wouldn't be protected by this rule. It is a rule specifically designed to protect purchasers, meaning you give value. Any other questions on that point? It's the kind of stuff, again, they're testing, a convergence of rules to see if you know the difference. It's exactly the kind of thing that shows up in these questions. All right. So I sum it up. I always like to, tie it up in a neat little bow if you have time. Nothing that's on this page is new. It's just what we concluded. Remember to conclude. It doesn't matter so much what you conclude if it's a factual question, but come to some conclusion and defend it. All right, so we've sold the property now. And if nothing else, the beneficiaries probably would ratify the sale, and we're gonna move forward. The homestead and the claim of the hospital. Now, remember, first of all, we're talking about homestead and the rule that I just mentioned before. If property is homestead, they've told you it is, so you don't have to guess here, then the owner of the homestead cannot devise it, period, end of story, if there's a spouse or a minor child. We know the kids here are adults. And so the rule then says you can devise to the spouse but nobody else, unless there's no spouse. Now, what do we do about the spouse? She's not dead. She's there. She's not divorced apparently, but she waived her statutory rights. And because she waived her statutory rights, we treat her like she's dead for the purposes of homestead. Which means that he can devise the homestead to the trust. And as you'll discuss, or as you'll think about at least when you get to Florida Con Law, if you haven't done it before, there's always an issue when you devise to a trust in terms of protection from creditors. That's a story for another day. All right, now, and all of this, of course, we've already covered. All right, now we've got a hospital claim. And here are the classes. Here's what I told you before you want to memorize. Interesting, I think. And I want to back up for a second. When we talk about payment of debts, as much as we'd like to distribute the gifts to the beneficiaries, you can't do any distribution unless and until all the creditors are paid first. First things first, creditors stand in line, they get paid off. And they're going to get paid off in this order. This is a statutory order. You can choose which of your assets you want to be used to pay your creditors, but you can't choose the order in which the creditors are paid. This statutory list has to go in this order. Take a look at that first class. I find it interesting. I find it amusing. Who gets paid first? We do. We take care of ourselves. The attorneys get paid first, and cost of administration. But the key there is we pay ourselves first. And then second is your reasonable funeral and associated expenses, not to exceed $6,000. Now, unfortunately, today, it doesn't get you very far, $6,000. It doesn't mean that the funeral home doesn't get paid. It just means the first 6,000 are in class 2, and then eventually we're going to get down to class 8, and the rest of the expenses will fall into class 8. Third, I also find this one really interesting. Debts and taxes with preference under federal law, Medicaid, and claims in favor of the state. Debts and taxes with preference under federal law. The feds don't get paid first. We pay ourselves first. Interesting. Class 4, an important one for this case, right? We put in class 4 reasonable and necessary medical expenses for the last illness for the last 60 days of the illness. Anything over the last 60 days, again, is going to fall down to the bottom to the catch-all class 8. And so the hospital bills we're talking about in this case, class 4. Would you need to walk through all these classes on the exam? No, I really wouldn't. But would I know that the hospital bill is class 4? You bet. They are looking for you to be that specific.
But you would mention 1, 2, 3, or you just say, oh, it's class 4?
On this question, because there's so much to write about, I'd go right to class 4. I put all of this in here because, once again, you can take this home, you can use it as a cheat sheet, if you will, and it gets you thinking about everything in the right order. But on the exam, in the interest of time, I'd probably go right to class 4. Because they didn't give you any other kind of claims. Okay, class 5, family allowance, $18,000 is your family allowance. payable to the spouse and to lineal ascendants, meaning parents, grandparents, and descendants, kids, grandchildren, etc., that the decedent either actually supported or was obligated to support. Class 6, it's the newest class, arrearage from court-ordered child support. Class 7, sometimes you have to continue the business of the decedent, and there you have it, debts acquired from continuing the business. And then our catch-all in Class 8, it's everything else, including the excess in Classes 2 and 4. And of course, if there isn't enough money to go around, you go in that order, and within any class, if you start to run out of money, it's pro rata within the class. Any questions about this particular, yes, ma'am?
I have Professor Butler. One of the things he told us is that this statute only applies when there's not enough money in the estate to cover all the expenses.
Well, right, the order, exactly. You're gonna pay, if you can pay them all, if there's a ton of money available to pay them all, then you pay them all and you don't have to worry about this order. But if there isn't enough to get all the way down to Class 8, that's the order you go in, absolutely. Any other questions? All right. And, you know, and of course, again, because it was hospital bills, if it was in excess of 60 days, because they don't tell us, then you're going to do Class 4 and Class 8. Now, I put a little bit of procedure in here. It's boring stuff, and there's always a question of how much of this picky procedural stuff you can keep in your mind. But at least some generalities might be very helpful. So here's basically what happens. They tell you it was properly filed, and here's what's going to happen. Personal representative is going to get those letters of administration and immediately do an inventory of the estate. Got to know what's there. And also start to notify the creditors. You publish in the newspaper twice, and you have to personally serve all known creditors. Then the creditors get the opportunity to respond and step up and say, here I am, here's my valid claim. Once the claims are submitted, the personal representative goes through them, says, yes, I'll pay this one, no, I won't pay that one. If the personal representative says, no, I won't pay that one, that creditor can then bring a separate claim. Think about it kind of like a tennis match or a ping pong match, and the ball is always going back and forth between the personal representative and the creditors. Remember, however, that you never get to distributing the gifts to the beneficiary unless and until all the creditors are paid first. Have to pay the creditors first. All right, and here it's not going to be a problem. We've got $100,000 from the sale of the homestead, $10,000 in cash, minus 25, so you got $85,000 for the trust. In this day and age, $85,000 for a trust doesn't get you very far. But it's an older question, and so $85,000 meant a little bit more at the time the question was written. All right. I'm going to go past the objection. We just talked about that and the conclusion. All right. So now, administration of the trust. And the key here, of course, is the investment of all the trust assets in the company, the construction company, that liver transplant, the support, down payment on the homes, and the car for Kathy. Plus, of course, her attempt to transfer to the zoo. We already identified the problem with the investment in the construction company. Trustee always has a duty to do what? Diversify. You can't put all your eggs in one basket. But, there's always a but, right? If our trustee in this case put all of the assets into the construction company, it could be a breach of fiduciary duty, but they tell you in the fact pattern that it was very successful. If it's very successful, what are the beneficiaries going to do?
Ratify.
They'll ratify. And the trustee can also go to the court and ask permission to invest all in one asset if the trustee thinks it's in the best interest of the trust. So in this particular case, while it looks like it could be a breach of fiduciary duty, it certainly appears that it was ratified to begin with. What about paying for the liver transplant? No problem. Certainly falls within the trustee's discretion in this case because the trust says for their health. And you need a liver to be healthy. Support of the twins while they're in college? Yeah, it says education, doesn't put a dollar limit on education. I'm looking at this and I'm adding up the dollars and I'm thinking that this trust went dry a long time ago. The math doesn't work out so great, but he was certainly, but maybe that investment was really good. Maybe you got a 20% return on that investment, I don't know. Down payment on the homes, as we said, yes. But the car, no. It's, Janet?
So for the right distribution of the trust, we will have to look at where the instructions, right?
Yes.
Given to the person.
Yes.
And what it would happen if we would say that it was not needed for the house? What it will happen? It will be the breach of.
Yeah, right. The question is, what if you decide that purchasing the houses for the twins didn't fall within health or welfare?
Yeah.
And I kind of think it does, but you might think it doesn't. Doesn't care whether it's yes or no. If I say it falls within that category, there's no breach of fiduciary duty. If I say that it doesn't fall within that category, it is a breach of fiduciary duty for which he will then have liability for breach of his duty. So that, exactly. And by the time we get to the car, I say, yes, it's a breach of fiduciary duty because it doesn't fit within the discretion that he has, which will then, I don't know where I have it, it's a little bit later, but which will then result in liability called a surcharge. He's going to have to pay some damages for his breach of fiduciary duty. All right, now, Kathy's attempt to transfer her interest to the zoo. There's a spendthrift provision. And you should look, if you get a trust question and it's got a spendthrift provision, take it as a gift, right? Because for the most part, when you've got a spendthrift provision, it's going to be something that you can write about, right? And you got to be happy when you can write about something, right? She can't. Because if there's a spendthrift provision, the beneficiary cannot voluntarily alienate or transfer the interest, which is what she's trying to do here, even though it's the zoo and we love the zoo, nor can the creditors get at the interest. So she can't do it. Now, it doesn't mean that if Tom was the trustee, if Tom pays out money to her and the creditor, the zoo, or whoever else it is, scrambles really fast, you can get the money before it disappears. But while the money is in the trust, you cannot, as a creditor, get at it except for our 3 categories of exception creditors. Alimony or child support as a last resort.
Fees in support
Anyone,
of the,
and these are important in Florida, they test it a lot. So alimony, child support as a last resort, certainly, that's the Bacardi case. Second, anyone who provides services, guess who?
The lawyer.
Who protects the interest of a beneficiary in the trust. We take care of ourselves, folks, so that's actually the first category. Anyone who provides services to protect the beneficiary's interest in the trust can invade the trust. Second, alimony or child support, but only as a last resort. And third, anybody know what that third category is? Oh, it's interests of the federal or the state government. Sounds weird, doesn't it? Could be taxes, but what it was really designed to do is to provide payment for medical services, Medicaid, Medicare overages. Under the common law, under the law of Florida for many years, if someone provided necessities to the beneficiary, that person could attack a spendthrift trust. And oftentimes it was medical services. That category has not been included in the statute. It's replaced by the governmental claims prong, the third one. And so if you provide necessities, you can no longer reach the spendthrift trust unless you're the government who provided services through Medicare, Medicaid, something like that. Yes?
Leave your meeting out there, the girls are gonna pick it up. Don't schlep the.
Okay.
Right.
All right, thank you. Oh, yeah, because I always take it upstairs because okay. All right, so, in this case, the zoo, of course, is not an exception creditor. It doesn't fall into one of those categories. So, zoo, you're out of luck. Unless and until she gets the money. Oh, whoops, I'm sorry. And those are our three categories. I should have put that up there for you if you want to write it down. Now, termination of the trust. I have to tell you, unfortunately, that it is a highly complicated topic. They love to test it. And so I say, do the best you can with it. When we talk about termination of a trust, first of all, we're talking about termination of a trust that is irrevocable. If it's a revocable trust, just pull it back, right? And a trust can be irrevocable from the start. But in Florida, the presumption today is that a trust is which? Revocable, unless the trust document expressly states otherwise. So your revocable trust, of course, can become irrevocable when what happens? Yeah, when your settlor dies. Real simple. And I'm going to go forward. In fact, I'm going to do it this way. It's faster. I would recommend, look at all these categories. That's why I say it's so difficult. Do the best you can. But take a look at this chart, which I put together. It kind of boils everything down. And say something intelligent if you can. Because if you can say something intelligent, most other people won't be able to. We've got different types of, you want to know everything, folks, but there are limits, right? The grounds for termination, power to terminate, date of the trust, and limitations. I'm not going to go through the whole thing, but I'm going to kind of go along here. I'm just filling all that in. Hang on. And then I'll give you some high points. Okay. We have judicial and non-judicial termination. Judicial termination means you have to go to court. Non-judicial means you don't have to, although quite frankly, a lot of times you end up in court anyway. We've got common law. The statute still recognizes the old-fashioned common law termination of trust, and we've got the uneconomic trust, which is what's relevant to this case, right? Is they tell you that the value of the trust is $34,000. That's this first one, which is the older uneconomic trust. If the value falls below, if the corpus falls below $50,000, then the trustee, acting on his or her own power, if you will, can terminate the trust. You can also terminate it if it is just uneconomic without a dollar amount. Then the trustee or a qualified beneficiary goes to the court. I would recommend you spend a little bit of time seeing how much of this you can absorb. Note over here, this is really hard stuff here. A couple of things I want to point out that you maybe can remember. Relevant, first of all, to this case. If there's a spendthrift provision in the trust, when you're talking about common law termination, a spendthrift provision will prevent termination of the trust, period, end of story. Under all of these other kinds of termination, a spendthrift provision will be considered, but it will not automatically prevent termination of the trust. Again, relevant to this question. Also, with common law termination, notice that there are two things you want to look for if you're talking about common law termination. One is a spendthrift provision, the other is an age limit. Because if there's any purpose left to be served, common law termination cannot be used. We've got an age limitation here. Because the kids are 31, the twins are 31, and the age limitation was 35. Now, last thing I'm going to point out, I'll certainly take questions on this chart, but the last thing I'm going to point out, you see mentions of the statutory rule against perpetuities. First of all, if you didn't know from your wills and trust class, you'll be happy to know that for all interests created in a trust in Florida, the statutory rule period is, anybody know? 360 years. Okay, maybe somebody out there will be here in 360 years. I'm not going to be. I'll give, maybe there's somebody out there who's gonna live a really long time. We have just said, thrown in the hat, really. We're not gonna worry about it. Centuries from now, they'll worry about the problem, which means nobody's gonna worry about the problem. But you'll notice for termination, we're using the 90-year rule here. The idea is that we're doing a little bit of trade-off. If you want to prevent your beneficiaries from terminating your trust, then draft it so it satisfies the 90-year rule, not the 360-year rule, with some additional limitations that you can read about. Okay, any questions? Yes, ma'am.
Okay, so these 4 types of ways to terminate,
Yeah.
are we supposed to talk about them all?
Well, in this question, here's what I would talk about in this question. It's a very good point. I would definitely talk about common law because we've got an age limitation and a spendthrift provision. The facts are telling you that you want to talk about common law termination. I would definitely talk about the uneconomic trust because they gave you $34,000. If that's all you write, you're getting a lot of points. Could this question also, however, best interest of the beneficiaries? Certainly the kids are going to say it's in their best interest, right? And trust purpose fulfilled or unanticipated events, well, the twins can't say that the trust purpose has been fulfilled because they're not 35 yet. So I might say that much, and I might say, well, is it really in their best interest? I don't know. Unanimous consent, notice that it is consent of the trustee and all qualified beneficiaries. Difference between non-judicial and common law. Common law, the trustee doesn't participate. There, the trustee must participate. I might mention that if the twins want to get together, they have to get together with Tom, our trustee. So, little things like that. That's about all I would probably do. It's all you might have time to do. All this stuff over here, I'd take a look at it and see how much I could absorb, but I wouldn't go nuts. Yes, ma'am.
Just for clarification, so would it be fair to say that there's 4 types
Yes.
of ways to terminate an irrevocable trust, and there are 2 ways to do it judicially, and then 2 ways to do it uneconomically?
Yeah,
Okay.
yeah, and you're saying a lot that most people can't say, right there. Absolutely, absolutely. And notice also, it's a failing on my part. I always just talk about termination of trust because that's how they test it. Notice that it's modification or termination. And so don't forget that these rules also apply to modification. It's just that on the bar, they're always testing termination. But see what you're doing. It's great, the questions that you're asking, and you're thinking, how can I say something and sound intelligent and correct without, right? Yeah, but without going, oh, geez, there's so many details here that there's no way I'm going to absorb them. Give them something, and once again, you've said a lot more than most people, and you're going to be racking up points. Okay, any other questions about this question? All right, what we're going to do then, we'll take a little break. When we come back, we're going to do a property essay. We're going to do something dealing with easements because it's something they like to test a lot. And easements, I got to tell you, if you can write a good easements essay, once again, you can really rack up the points. Thank you. Let's go ahead and get started because sooner you didn't do it? I didn't. I didn't see the, yeah, they were here.
The leader does focus on the stuff that they
I'm
I have called upstairs.
It's for the hotel. Oh, it's okay. I'm staying at somebody's house.
Okay. All right. Thanks very much. I'm going to do the drawing, and then we'll talk some property. And Dayron was asking about homestead. we're gonna be talking about Homestead, not today, but later, so we'll come back to Homestead, and I gotta tell you, as I think I said before, they are overdue on Florida Con Law, so you wanna be prepared on Florida Con Law, and they love, love, love Homestead, which combines with property, which combines with trust, which combines with a lot of things. So would I be prepared for Homestead? Yes. And again, we're going to be talking about it later. Yes, ma'am.
Those multiple choice questions we started with, the answers to the questions we didn't do, are
Yes.
those available on the Blackboard? or
They
am I
should be.
missing them?
If I have to check that. If they're not, we'll get them up. And because I have analytical answers.
Okay, we need those.
Okay, we'll get them up. Again, I wrote analytical answers for all of them. All right.
Thank you.
Okay, I have, where's Marlene? Marlene? Oh, there. Okay, yeah. All right. Marlene is our winner today. All right. Okay, property. As I mentioned, at least to some people, we're gonna do an easement question. That's a frequent flyer when it comes to Florida essays. And there is specific Florida law in here, you may not know it yet, but I do like to do this question from time to time because of what's in it. It is a particular issue that they test a whole lot. So take a few minutes and see what you see in this question, and then we'll talk about it. And I'll take this Marlene's upstairs while you guys are doing that. once again, of course, if you were actually doing the exam, you would take more time to map everything out, but let's do some mapping together. All right, we've got Art, who owns Lot 1, and it's on Crystal Lake. They tell you it's Florida, good, we're going to apply Florida law. Bud is the owner of Lot 2, which is situated behind Lot 1 and overlooking Lot 1 to the lake. Actually tells you something right there. What does it tell you? I'm sorry?
It's elevated.
Well, it's elevated, yes. Thank you, Joe. Yes, it's elevated. What else besides it's
It's
elevated?
unimproved.
He wants to be able to what? See the lake. View. Thank you very much. The question is, are we going to have an easement of view? And we're going to find something interesting about Florida. Remembering always, they love to test these Florida nuances. So, he is situated behind, he wants to be able to see the lake. Lot 1 is landlocked by the lake and Lot 2. So right away, you're thinking about what? Okay, an easement by necessity is a type of implied easement. But what don't they tell you that you need to know for any kind of...
Whether it was owned by one person.
Ah, good, because whether it's just an easement that is implied by prior use or an easement by necessity, which means there's no prior use, you have to have that initial unity of ownership, which doesn't appear to be present here.
Doesn't Florida have
Yes,
extensions?
it does.
Doesn't
Well,
have to be?
Florida has a separate way of proving an easement. Florida recognizes the traditional implied easement. It also has a statutory easement of way by necessity. You have to talk about them both. To maximize your points here, you talk about them both. And we will indeed talk about them both. So it's only access to the main highway is a dirt road, which is significant to that statutory easement by way of necessity. And there's no reference, of course, in the deed to the dirt road. In 1975, well, it's an old question, but it's also a long time ago, Art and Bud signed an agreement by which Bud paid Art $3,000 in return for Art's promise not to build any structure on Lot 1 that would block Bud's view of the lake. And so it appears they were trying to create what?
Negative.
Negative easement, good. Because if someone says, I promise not to do something on my property, that's a negative easement. But your traditional negative easements, how many?
4. Fair, spring.
Light, air, water, and lateral side and subjacent support. The list doesn't include view, but guess what? Florida does. Ah, specific Florida law, all right? And of course, an easement, a negative easement must always be in writing. You can never have a negative easement by implication or prescription. It must always be in writing. All right, since 1970, Bud has used a path along the east side of Art's lot to reach the lake. Over the years, he's kept the path clear of overgrowth and installed railroad ties along the side, so we see that we have what?
Prescriptive.
Okay, the question is, do we have a prescriptive easement, because he's actually using, and there's some interesting little Florida nuances on that issue we'll get to in a moment. In 1975, Charlie, who's the owner of Lot 3, starts to use the path too, and that's also significant for a couple of reasons, one that might appear obvious and one that isn't so obvious. Art complained about the noise and trash left on his property, so he posted a no trespassing sign along the path, which is trying to suggest what? Okay, whether their use will continue to be hostile, and they did continue to use the path even though he said no. So the use was not what word? Permissive, right? If he says don't use it and they continue to use it, it's not permissive. If it's permissive, it can't be prescriptive, right? Last year, Art died and daughter inherited Lot 1. Well, when she inherits Lot 1, she steps into his shoes, right? Can we tack for prescriptive easements? Yes, we can. Just like we can tack for adverse possession, you can tack on both sides, on the side of the user and on the side of the owner. Before he died, he told daughter about the 75 agreement. Why is that significant? Oh, well, she can't claim, well, she can't for several reasons, claim that she is a subsequent bona fide purchaser for value without notice. Number one, she didn't pay value. And number two, she's got actual notice. By the way, they love to test recording on the Florida essay. You'll be so glad to know. Florida has what kind of recording statute? Does anybody know? Pure notice. It's a notice recording statute. If you didn't know that, learn it and be able to say something intelligent about recording in Florida, because if you get a property essay, it's a very frequent flyer. All right, so he tells her about it. Last month, of course, then daughter constructs an addition to the house, and the addition, of course, blocks Bud's view. And she says to Bud and Charlie, you can't use the path. So now Bud, in retaliation, blocks off her access to Lot 1, naturally. Now, the call of the question here is not your typical call of the question today, because it just says discuss. We were talking about call of the question on the brink. You will almost certainly get a very pointed call of the question in the plural. Probably spell out several issues, regardless of the subject matter of the essay. The new style of essays, which Florida uses. Florida does not use the new style of multiple choice, but it does the new style of essay. The new style of essay has a very directed call of the question. Answer the call of the question and in the order in which it's presented. You can't do that in this question. It just says discuss. But understand that your essays are going to have very guided calls of the question. So, where do I go? I took each of the property interests. Property, it makes sense, doesn't it, to go through each interest separately. You might have another way of organizing the question that's appropriate for this particular question, since the call of the question is so vague. I'm giving you a suggested method. So, we'll start with her right-of-way over the dirt road to get out of Lot 1. I wouldn't spend a lot of time talking about express easement here. Why? We don't have an express easement, right? There's no writing, and they tell you that. That's all I would say. I have a little bit more in here. Again, study guide. They have told you that there was no written easement. That's all I would say, no written easement, so no express easement. But we do want to talk about an implied easement. We do want to talk about a prescriptive easement. So let's go forward to implied easement. And as I just mentioned, the Florida statute expressly recognizes the common law implied easement, which includes that easement by necessity that some people call it. So you have to discuss it. And it's got a separate statutory section. So let's start first with the implied easement. And we know for an implied easement at common law, we need three things. First, we need initial unity of ownership, one big block of property. And we need severance of the unity. And then we need what I always call the requisite degree of necessity. If there's a prior use, how much necessity do you need? Reasonable necessity if you have a prior use. If you don't have a prior use, you need strict necessity. Now, there is a somewhat of a modern trend that requires just reasonable necessity for even an easement without prior use, but the traditional rule requires strict necessity. So, we start with initial unity of ownership. Well, there isn't in the facts. And you could stop right there and say, well, the facts don't tell you there was initial unity of ownership. I might, in this case, say, but if there was then, I don't think that's really negative issue spotting, because they've given you facts so you can talk about the necessity, because it's landlocked and she can't get out. I always say let those facts be your guide. So what I would say is, she can't, but if she could demonstrate then. And the question is, was it reasonably necessary? Because remember, there is a prior use here. So reasonable necessity is all we need. And this language here, reasonable and practical way in and out of the parcel, that's from Florida cases. I wouldn't get too hung up on that particular part here. I'm going to be giving you here a lot of language. I found some more recently too, kind of interesting, when we get to prescription. That is Florida-specific language. If you can remember it, great. If not, then at least use reasonable necessity. It'll get you pretty far. So, I'm going to go past that. And once again, this is study guide stuff talking about the difference between a prior use and no prior use. What I want to talk about, if you get an easement question, it can kind of write itself. Because first you have to identify what kind of easement you have. Is it express? Is it implied? Is it prescriptive? And then you want to know how it's created. We just talked about the elements for creating an implied easement. Then, can it be transferred? Because remember, we've transferred this easement from Art to daughter, right? And then, if it can be transferred, I guess we're glad we're in here and not out there. Hopefully it'll blow over before we leave. If it can be transferred, then how is it terminated? And all easement analyses kind of follow that same arc. What is it? How's it created? Scope sometimes, although that's not a big deal here. Transferability and termination. And if you go in that order, you'll have a nicely structured easement answer. So here, what happens when you transfer the dominant estate? The easement automatically goes with it, right? Not a problem in this case, because daughter inherited from Art, so we do have a transfer. How long does it last? Well, it can last in perpetuity unless and until it's terminated, right? Every once in a while, they'll give you a shorter easement. You can have an easement that's for 20 years or something like that, but obviously not in this case. So, you know, if an implied easement was created for Art, he transferred it to daughter when she inherited from him, and it is potentially perpetual. And an important point, at common law, if an implied easement is created, the owner of the servient estate is stuck with the easement and does not get any compensation for it. We're going to see a different rule for the statutory easement of way by necessity. Again, they're definitely wanting you to state that difference. Again, no compensation due to the owner of the servient estate for the common law easement that is implied. Now, statutory easement of way by necessity, take a little bit more time with it because they love to test it. It shows up so much in property questions. And it's easy to analyze. That's the good news. It breaks down very nicely. So, what do you need? First of all, you've got to have land that's outside a municipality. They haven't told you here. It's on a lake, so maybe it's outside a municipality, and I would say, if it is, then. Second, key, it's got to be used for dwelling or agricultural purposes. A lot of Florida rules talk about agricultural purposes, and Homestead, that 160 acres outside a municipality, it's aimed at farms too. You know, we are a big farming state. So dwelling or agricultural purposes, we've got a home here. Daughter, because she's building an addition to her home, so dwelling purposes. And the land has to be so hemmed in that there's no, again, that reasonable route of entrance or exit available. And they've clearly told you that lot 1 is landlocked. Now, if that easement has been created under the statute, which it probably has in this case, take a look. The owner of the dominant tenement must compensate the owner of the servient tenement. Common law easement, no compensation due. Statutory easement of way by necessity, compensation is due. And if you can make that distinction in a question like this, you're picking up a lot of points that other people aren't picking up. Remembering again, that this is an area they love to test. I can't tell you for sure that they're going to test property or if they that they're going to test easements, but if they do, this is very typical topic within easements. All right, now, prescriptive easement, important. And the good news with prescription is that it is very similar, of course, to adverse possession with some differences, which is what you want to highlight. And Florida has some little twists here that might sound different from what you learned in your property class in terms of common law prescriptive easements. First of all, with prescriptive easements, the first thing to note is that you're talking about use and enjoyment rather than possession, right? In terms of difference between prescription and adverse possession. So use that vocabulary, use and enjoyment. And then second, of course, your prescriptive period is in Florida 20 years. In Florida, adverse possession is 7 years. But prescription is 20 years in Florida. So, otherwise, we're going to see very similar looking elements. Joe, go ahead.
You're about to get to it when well, actually, no. With the transfer of the title of Lot 1, does the clock start over?
No, we're going to get there.
Okay.
Okay? It doesn't normally, but I'll explain that when we get there. Okay? All right, so, first of all, open, right? And Florida says open, visible, notorious. The open is something, at least traditionally, that says to the owner, somebody's on your property, and open and visible. And notorious says to the community, somebody's out there. And in Florida, notice this is the Florida part right there. The owner has to know, or either know or through a reasonable inspection should know that somebody's out there. So when we talk about open in Florida, we're saying owner, you should know, or you should have inspected. Of course, in this case, they're going back and forth on that road all the time, so there's no way that Bud, and I guess Charlie too, since Lot 3 is behind Lot 2, there's no way they didn't know. Notice also what I'm doing here as a general principle when you're writing your essays. Do not say, here are all of the elements and all the rules for adverse possession, or in this case, sorry, prescription, and then here are all my facts over here. Integrate them. You can state the basic elements if you like up front, but then take each element, define it, apply it directly to the facts, and then move on to the next element. The way you make your analysis pop off the page is by blending law and fact, and you will pick up a lot more points if you integrate law and fact and show that analysis. So what I'm doing here, I state the rule and then apply it directly to the facts. Remember again in Florida, owner, do you know somebody's there? Actual, well, okay, you're physically on the premises, which clearly they were. And notice also again, a specific Florida rule, not the most important thing, but if you can remember it, great. You gotta have a specific place that you're walking. You're not just kind of wandering, but it's a path that you follow. That's what delimited means there. You follow the same path every day. You can see it. It's worn into the ground, or in this case, a dirt road. Hostile. Okay, hostile can mean different things, right? But in Florida, it means without the owner's permission and under a claim of right. It's not going to rise to the level of the aggressive trespasser and some of those things you talked about in your property class. But you have to say, I'm going. And the owner said, and without the owner's permission, which is clear here. because when Art said, no, I don't like all that noise and trash, they just kept Bud and Charlie, just kept going. I said that backwards, I'm tired. Art and daughter are the ones who were walking, and Bud said no. Okay, tacking, that's Joe's question. Can you tack? And the answer is yes, as long as you have what? What word? Privity. Okay, good. Very good. Art died, daughter inherited. Do we have privity? Yes, we do. So you can tack on both sides as long as you have privity, and she is in privity because she's his heir. All right, 20 years. A little fuzzy in this case because we don't know when Art first started using the road, but it sure looks like it. It's been a long time because at some point they talk about 1975, the question set in 2001. That's probably good enough. Now, exclusive. And I put this one last, and note this. Sometimes you need to talk about elements in the right order. And for example, if you're talking about an implied easement, first initial unity of ownership, then severance of unity, and then requisite degree of necessity. When it comes to adverse possession or prescription, you can take the elements in whatever order works for you. I put it last here because here we have a difference in Florida. And you may have learned in your property class, especially if you have me for property, that when it comes to a prescriptive easement, the exclusivity element is either not there at all, or it's really watered down, and it just means that the whole world isn't using the property. Understand, of course, that with a prescriptive easement, oftentimes it's shared. The path is shared with the owner. Florida has some specific rules here, because it's got to be either exclusive or inconsistent with the rights of the owner to use the land. So it is a little bit more limited in Florida than it is under the common law rule that you may have learned. Now, obviously, if it's not either exclusive or inconsistent, then it's deemed to be permissive. And if it's permissive, of course, it's not hostile, which means no prescription. Yeah, I don't know here. The facts are kind of on the fuzzy side. We don't know. We don't know if they were the only ones using the road. We don't know if the use of the road was inconsistent with Bud's use. A little fuzzy, but at least you note the Florida distinction there. Okay, so I conclude then. Doesn't matter what you conclude, march through your elements. All right, Bud and his view of the lake, negative easement. I added in covenant that runs with the land / equitable servitude. Now, the main thing here is going to be the negative easement. The covenant is really a minor thing. Equitable servitude, maybe. Because if it's not a negative easement, even though it probably is in this case, then still you have a writing and something that might look like a servitude. So let's look at that negative easement first, though. It's clearly what they wanted you to talk about. Normally, common law, there's no negative easement of view. But Florida, yes. So what do you need? You need the writing. And we have a writing here. And then again, if, as is the case, Florida recognizes that easement of view, negative easement of view, then Bud has the right to enforce it against daughter. Now, if she's already built her addition, what are we going to do? Money damages. Can't, at that point, they're not going to make her knock it down. It's always the problem with this type of easement question, also with nuisance. If they test nuisance, you can't complain till something goes up. Bud can't complain, I can't see, because there's nothing there to block his view. But once so he can't get a remedy then, but once it goes up, it's too late to knock it down. So at best, he's probably just gonna get money damages. Transfer, did the transfer in this case terminate the easement? Remember, you identify the type of easement, you talk about how it's created, what its scope is, and then you consider its transfer, is it transferable, and does the transfer terminate the easement? Because remember, the property was transferred from Art to daughter. What do we think? Did the transfer from Art to daughter terminate this easement?
Yes.
No. Why not? Think about the facts. Why not?
Because he's over.
Oh, she had notice? Wow. She is not a subsequent bona fide purchaser. We have two things going here. She didn't pay value. To be protected by the recording statute. She's going to say, hey, and they tell you it wasn't recorded. She's going to say, hey, it wasn't recorded. I'm protected. But she knows she's not. Number one, she didn't pay value. To be protected under the recording statute, you have to pay value, right? And even if the easement wasn't recorded, she had actual notice. She was told about it. So the transfer to daughter through the inheritance does not terminate the easement in this case. All right, now, I'm going to skip past the covenant that runs. That's material that's in there for you to kind of think about. Usually, you don't need the covenant that runs with the land and law analysis. Why? Because almost always, what the person who is the plaintiff, who's complaining, wants is injunctive relief, not money damages. And you're talking about money damages when you talk about covenants. So I'm going past that, although again, the house is probably not going to be torn down here. And I went through all of the elements of a covenant that runs, again, as a study guide more than anything else. But past that, and we should talk about servitude. All right, so an equitable servitude, of course, is the flip side of a covenant that runs with the land at law. What do you need for an equitable servitude? You need a writing or some kind of substitute, but we have a writing in this case, so it makes life easy. Intent, you got to have intent for the servitude to run. The writing makes that clear here. Easy. Do you need privity? For a servitude, no, you don't need privity. Covenants, maybe in some jurisdictions, but servitudes, no, you do not need horizontal privity between original parties to the agreement, which you didn't have in this case, did you? It's between Bud and Art, and there wasn't privity there. Do you need vertical privity? Probably not for a servitude. Yeah, there's and the third restatement gets a little funky on that one, but probably not.
Going back to the intent element, I know under like the common law and stuff, for it, the intent to run, you have to actually designate in the writing that it goes to your assigns, heirs, so on and so forth. It's Florida different because we don't have that.
Yeah, what does the writing say here, though? It's a good question, and I skipped over that, but it is, look at the writing. What does it say? Let me go back there. And actually in my answer, I actually talk about that. To assure an unobstructed view from Bud's house. So, the question there is, when it says to assure an unobstructed view, that may indicate that it is intended to run, but then it says from Bud's house. So it's a little contradictory there. And in my full answer, actually address both of those. I think, or at least my conclusion was, you can conclude whichever way you like, that the idea was you're not going to block the view from this house going forward. Valid point though, and I did kind of go fast over it, but it is addressed here, and I would address it. Vertical privity, I would say that mostly you probably don't need it, but if you do, notice is always going to substitute for vertical privity, and we have notice in this case. Now, touching concern. touching concern is very important for servitudes, so don't forget about it. It's more important for servitudes than it is even for covenants. What does touching concern mean? The benefit touches and concerns the land if it increases the value of the benefited land. And the burden touches and concerns land if it decreases the value of the burdened property. So let's translate that into this fact pattern. The benefit, if we're talking about a servitude here, the benefited land is Bud's land. What's his benefit? View of the lake. And think about it for a second. Is his property worth more or less if he has a lake view? It's worth more, absolutely. The benefit touches and concerns his land. The burden is going to affect Art/daughter's land. And the burden again touches and concerns the burdened land if it decreases the value. Is her property, daughter now, is her property worth less to her if she can't build the addition? Yes, she wants to build that addition. She can't do what she wants to do. So the burden touches and concerns. And when you're in equity, you want to make sure that the benefit touches and concerns and the burden touches and concerns. It's very important. All right, now, most of what I have in respect to Bud and Charlie and their use of the path, we can go quickly over unless you have questions, because guess what? We're repeating. Implied easement, same issues, right? We're going to talk about both the common law implied easement and the statutory easement of way by necessity. Prescriptive easement, because they're using that, that little path to get to the lake, same thing. But look, we've added something different, irrevocable license and easement by estoppel. And that particular issue we haven't discussed, and it's something that's easy to test. So I'm going to kind of go past this implied easement unless anybody has questions. Because the issues are largely the same, except that, what are they using that path for, Bud and Charlie? To get to the lake. What was daughter using the road for? To get out of her property. If you're talking about a common law implied easement, is there any kind of necessity of any kind to get to the lake? No, they're just hanging out at the lake. So it makes an implied easement, but under the common law, difficult to prove. And think about, and go forward, that statutory easement, because remember, the land has to be hemmed in. And here we're just talking about a path to the lake. So both of those are difficult to prove for Bud and Charlie. Prescription, we go through the same elements, and we have many of the same issues, quite frankly, here. And so I'm not going to take more time to continue to go through those elements. But I do want to get to okay. Easement by estoppel, irrevocable license. Something that starts out as a license, permissive of course, can turn into an easement through, guess what? Estoppel. So if we view the use of that path to get to the lake by Bud and Charlie, if we view it as just a license, of course a license is a highly revocable thing, and it's permissive. If it started out life as a license, and it might have, it can turn into an easement if the elements of estoppel are proved. So what do you need for estoppel? Everybody loves estoppel, everybody knows estoppel. What do you need for estoppel? First you need
Permission.
a what? A promise or an act, right? If it's promissory estoppel, you need a promise. If it's equitable estoppel, sometimes called estoppel in pay, you need some kind of act or representation. Here it would be, go there. Sorry, we just talked eventually, daughter, but focusing first on Art, did he let them use the path? Yeah, it seems like Art let Bud clear the path. Maybe it's permissive to start with, but that's at least an act or a representation. He's letting him clear the path, right? Second, we need actual and justifiable reliance. Did Bud, when he cleared the path, did he actually rely? Sure, because he cleared the path, right? What do you think? Was it justifiable reliance? Yeah, you can say yes, you can say no, but it sure looked like it because Art didn't say anything to the contrary, and maybe he liked having the path cleared. So, then you need your three elements for estoppel, either the promise or the act or representation, the reliance, and you need an injustice in the form of, guess what, reliance damages. Well, they're just going down to the lake, I don't know, to hang out or catch fish or, you know, whatever. So the damages might not be great except for whatever Bud spent to clear the path. But he has some damages. And will that be enough to rise to the level of an easement by estoppel? You know, you tell me. But those are the steps that you're going to go through. So, moral of the story, I guess, when it comes to an easement question, go through those steps, elements, but remember what kind of easement is it, how's it created, what's its scope, can you transfer it, how's it terminated? And if you go through those steps, any easement question will right itself. Any questions that you all have? Yes, ma'am.
It's not a question, but would you be able to upload the slides? Because the ones we have are not exactly the same.
Oh, this is the newer version. I'm sorry, you know what happened is Susie just transferred over an earlier version. Yes, we will upload these. I apologize for that. Didn't know that this wasn't put up there. As I said, I did some research recently. I always like to go back and revisit this stuff. I don't just, leave it. It is a question I use from time to time. And as I did some research, I found some interesting things. We'll get that posted, no problem at all. Probably not till Monday. I might be able to do it over the weekend, but if not, we'll definitely do it Monday. Any other questions? I know I want to let you guys get out the door, and it looks like it's not raining at the moment. Please remember that Judge Shepard will not be next Friday, the following Tuesday, the 28th, in this room at 2:30, followed by the barbecue. So we'll see you then.